Who are you representing in that case?
Okay, we represent three parents, three mothers who live in Kalispell, who have children who are attending the Stillwater Christian School in Kalispell.
And I understand your disagreement is with an interpretation by the Montana Department of Revenue. Is that right?
Correct.
Can you kind of explain just briefly what that disagreement's over? Yeah, thanks.
Of course. Montana has joined about 30 other states in enacting a school choice program. Montana's particular type of program is a tax credit-generated scholarship program. So the state provides donors, taxpayers, with a tax credit. And there's like 25 or 26 tax credits that you can take in Montana against your personal income tax. And this is if you donate to a scholarship fund, which is basically a 501c3 charity, okay?
Mm-hmm.
And you get the tax credit, you donate to them, and then this charity, and there's one operating in Montana. Actually, there's two, but one is participating in the program. They take the donations and bundle them into scholarships for students who qualify, which is basically means tested, meaning if you're low income, you can get these scholarships, provided enough people contribute. The statute as written says that any private school can participate in the program, and so any parent can apply for a scholarship for their kid to go to any of these private schools. It's a way of creating competition for the public schools and providing parents with additional educational options for their children. And the Department of Revenue has interpreted the statute and the Constitution of Montana as requiring that they exclude religious schools from participating, and thus any family that wants to send their children to religious schools using these scholarships. And in Montana, like everywhere else in the country, the majority of private schools are religious schools, and so this rule that they promulgated has the effect of preventing our clients, the three families up in Kalispell, from getting scholarships to send their children to the school of their choice, which is Stillwater Christian School.
So do you think you have an argument on the interpretation of the Montana State Constitution? Is that the thrust of your case?
Absolutely.
Well, what is your case on that?
This case has been going on for approximately 6 months now. And at the end of March, the judge granted our motion for a preliminary injunction, saying that the rule that DOR promulgated is unconstitutional and is beyond their authority and a misinterpretation of the statute. And it's not just us who think that. When the rule was proposed by the Department of Revenue, the Attorney General's office filed comments in the public rulemaking, which said, number one, this rule is not required by the Montana Constitution, and excluding the religious options violates parents' constitutional rights itself. And they told DOR they wouldn't defend them in court, and so DOR is defending itself in court.
Do you feel like it's something that goes all the way to the top of DOR to Mr. Cadis, or is there someone else?
Oh, he's certainly aware of it. I mean, I think that this was, very controversial what the department did. It was controversial when the legislation was considered. And it unfortunately breaks down largely upon party lines, with Democrats saying it's unconstitutional and not supporting the bill, and Republicans passing it and saying it does. Now, the governor never signed it and never vetoed it, so it became law over his veto. But, they're basically trying to accomplish through a regulation what they couldn't accomplish in the legislature.
It's interesting that you say that. For many, many years, the state teachers union, the MEAMFT, they've repeatedly used this idea that it's unconstitutional to have any state money flowing towards a private school of any kind.
And I think that's, this is a little different from your typical scholarship program, because a typical scholarship program, the state actually provides the scholarships. In this particular case, the state isn't doing that. It's providing tax credits to families, which say if you want to donate to XYZ school or XYZ scholarship fund, you can do so. And in theory, I mean, it's no different from what Montanans have been able to do forever on their state income tax when they make a donation and it's tax deductible. Now, a credit is more valuable to the taxpayer than a deduction, but it's no different in legal structure. And, of course, Montana, like every state in the union, also provides tax exemptions to every private school in Montana, including all of the religious ones, which is a much more direct sort of benefit to the school, because it's not, limited to being provided to families who then buy an education from the school. It helps the school, tax exemption helps the schools as institutions.
Now, I understand, well, when I spoke with Mr. Cadis about this, he said that it was kind of a damned if you do, damned if you don't situation for him, that he was going to get sued by someone, and he just picked one.
I think that's it's possible that the MEA MFT would have sued, but just as a matter of fact, I mean, one of the things we do at the Institute for Justice is defend these sorts of school choice programs. Montana has been unique in our experience in that it's the state which has excluded the religious schools by this rule. It's typically the Department of Revenue in, say, Arizona, for example, where the first of these sorts of scholarship programs was passed. The state implemented the legislation as written, and yes, they got sued. And that's happened in, half a dozen other states that have done these tax credit scholarships. But none of them have been struck down for including religious schools. All of them have been upheld.
And you've been involved directly in those?
Pardon me?
Have you've been involved directly in those lawsuits?
Yes. We've been involved in all of those representing families as intervener defendants.
Wow.
But Montana's unique in that because the state, the Department of Revenue, took the opposite side, we're representing plaintiffs.
Is this the first time this has happened? It is unique,
that
you
we've
said.
represented plaintiffs? Yes, it's the very first time that a Department of Revenue has interpreted the Constitution to say that the statute as written would be unconstitutional if they implemented it as written.
And again, here we're talking about the state constitution of Montana, right?
Correct. Two different provisions of it are relied on by the Department of Revenue. One of them obviously can't be relied on. The other one we think they're just grossly misinterpreting. But the first one, which is a provision about taxation, Article 5, Section 11, subsection 5, would invalidate the whole program and not, permit them to exclude the religious schools. They'd have to say the whole program was unconstitutional as an appropriation for educational purposes.
I was curious. I understand that you were expected to file some extra paperwork today, right?
Yes. I mean, following up on our preliminary injunction, yesterday the Department of Revenue finally got around to filing their answer to our complaint. When you file a complaint, normally the other side files an answer. They filed a motion to dismiss instead. That was denied at the same time the preliminary injunction was granted. Now they have finally answered the complaint, basically. And so now, as far as we're concerned, because there are no real facts necessary, it's all legal questions, we have filed or will send to the court today, a motion for summary judgment, which would resolve the case totally at the trial court level if it's granted. And then you go appeal it to the Montana Supreme Court.
Do you expect to wind up in the Montana Supreme Court?
I think it's almost inevitable. If we lose in the trial court, we would appeal, and if the DOR loses, I think they would appeal. There's only the two levels in Montana because you're a relatively small state, like many others, and so you just have one appeal level, and that would be the end of it. And we would expect that they would appeal it because they've already lost a preliminary injunction, and the standard for that, among other things, is who's got a substantial likelihood of prevailing on the merits. So the judge has already said we have a substantial likelihood of winning on the merits. If they were going to capitulate, they should have done that at the time of the preliminary injunction. So they'll almost certainly appeal.
Wow, it's so fascinating. I'm going to stop my recorder now.